Good morning still, right? Yes. Good morning, everyone. I'm delighted to be here this morning. I have to say that I joined IABA as a member back in 2008, and then I ended up joining as one of the leaders of the organizations, and to be here this morning in this capacity truly feels full circle. So I'm eager to see which one of you members is going to be a future judge and a future panelist here one day. Sara Izadpanah asked me to talk about my path to the judiciary, and it's not really a blueprint. It's not something that is an exact path for everybody to follow, but to the extent that it might shed some insight on one person's journey, I hope that you find it informative. And I'm going to go way back to my kindergarten year, actually. So I'm really going to talk about my path, but of course, speed play it at parts. When I was just 5 years old and living in Iran, my father received a fellowship from the World Health Organization to attend Stanford University for environmental engineering. And my family and I moved here for that purpose. It was an extremely formative year in my life, and I dreamed of attending Stanford one day myself. Now, fast forward to college application days. By then, we had moved back to Iran. Then the revolution happened, and then we moved back to the United States, this time having fully immigrated. And when I was applying to colleges, of course, I had my heart set on Stanford. My father being an alumni, I knew how tough it was to get in, but I was realistic, but applied anyway. And then a few months later, I got an envelope in the mail. And the common wisdom at the time, and probably still applies today, is that if you get in, it comes with a nice big thick envelope full of the welcome and enrollment information. And if you don't, your envelope is thin. My envelope was thin. So I mourned it a while, and life goes on. Now, fast forward to 2013, more recent history. By then, I'm a full-fledged attorney. I'm prosecuting crimes as a deputy district attorney in Santa Clara County, teaching at Santa Clara Law School, and a lot of other community activities. And one afternoon, I went to check my office mail, and among the stack of envelopes of legal mail from opposing counsel and whatnot, there was another envelope from Stanford. Another thin envelope from Stanford. So I had momentary PTSD, and I opened it. And this time, it was an invitation from Stanford Law School for me to teach at their program in trial advocacy. So it was a little inner smile and a lesson in perseverance to pass on to my kids. Now, what happened between that first thin envelope and the second thin envelope, and ultimately the judiciary, is the path that I will be sharing with you this morning. And as this graphic depicts, the path to success is not linear. And I recognize that each person has their own definition of success, but for purposes of my path to the judiciary, it was full of ups and downs and U-turns and disappointments and setbacks and ups again, and it was convoluted. So that's why I say it's not like an exact blueprint to judgeship, but that's what I will be sharing with you today. When I was applying to law schools, I didn't know what type of law I wanted to practice. I didn't have a particular specialty in mind, but I just had the overarching goal, perhaps generic or idealistic, that I wanted to help others. And I also knew that I wanted to do trial work because of speech and debate that I had done in college. I knew that I wanted to be in the courtroom. I didn't want to do transactional. Santa Clara Law School's program in social justice really resonated with me. Here they were in the heart of Silicon Valley with a lot of programs in patent law and high technology law, but what resonated most with me was their program with social justice. And I entered Santa Clara Law School with that in mind. And then during my summer associate positions, I thought I wanted to do civil litigation. And litigation, of course, trial work, civil, because criminal is just too harsh. But when I did some work at civil law firms, I recognized in myself that arguing over monetary disputes was not personally fulfilling. And a lot of people also told me that if you're really serious about wanting to do trial work, unless you're a very experienced partner, you're not going to see the inside of a courtroom. And if you really want to do trial work as a young attorney, going the criminal route is the way to go. So I gave it some thought, and I decided, okay, with criminal, that's a no-brainer. If it's between DA's office and public defender's office, that's a no-brainer, public defender's office, because I like to root for the underdog, and that's where I thought that I would be better suited. I did an internship at the public defender's office, and ironically or interestingly, it was through that experience that I thought, even though I like to root for the underdog, I found myself better suited to take that compassion and advocate for victims of crime, which would be at the district attorney's office, while still being very mindful of the rights of the accused and making sure that all constitutional principles are abided by. And then I sought to get a job at the district attorney's office. In Santa Clara County in particular, it is extremely challenging, extremely competitive to join the DA's office. They had a volunteer attorney position. This is people that had already passed the bar, and they could come in for 3 months, get some trial experience, and then get out, but also get their foot in the door and see if it's going to work out. I applied for that volunteer position. The interview went well, and I didn't get it. And I was so discouraged. I remember telling my husband, they don't even want me for free. I mean, can you imagine? Like, I just want to volunteer my time. So that definitely was discouraging. But I did other things. Life goes on among your journey. I kept my eyes at the DA's office, and I kept in contact with them, and I kept applying. And then ultimately, I was allowed to come in for just that 3 months, and they pounded and emphasized over and over again in the interview that there's no guarantee of employment. There's no guarantee of employment. I understood, but I accepted wholeheartedly. I just wanted to get my foot in the door. It was a 3-month position. 2.5 months into it, I was hired as a deputy district attorney in Santa Clara County. Thank you. And this is with the legendary George Kennedy in Santa Clara County. And I later learned that I was the first Iranian-American DA ever in the history of our county. Now, those early days came with its own challenges. On the misdemeanor trial unit, where everybody starts off, there were 7 of us, 6 men, and yours truly. And I vividly remember being in court one afternoon, and a defense attorney, a male defense attorney, came up. I'm at counsel table. I mean, I don't know what more circumstantial evidence you need than that. But he came up to me and he said, "Excuse me, are you the Spanish-speaking interpreter? Do you know when the DA is going to get here?" And I just smiled and I said, "I'm sorry, I don't speak Spanish, and I am the DA." Reflecting on it, I didn't take offense. I don't think he was trying to be disrespectful. He just didn't know better. He didn't expect the petite, olive-skinned young woman in the courtroom to be the DA. Even with the new hires, even in that generation of new hires, the 7 of us, like I said, I was the only woman, and out of the other 6, there were 5 white men, 1 African American, and myself. But slowly, we changed the face of the profession. We slowly changed the face of DA's office. We add to its diversity, as we've been talking about how important that is, and we add to its perspective. So at the district attorney's office, I had various different assignments. As I mentioned, most everybody starts off as a misdemeanor trial attorney, and then I prosecuted narcotics, robbery, carjacking, assaults, a lot of blood and gore. And then I went to the environmental crimes unit and also consumer protection unit, and had wonderful opportunity to represent the people of the state of California, advocate on behalf of victims of crime, but of course always respecting the rights of the accused and making sure, as my initial love was, to make sure that the accused gets a fair trial and cases are dismissed if the evidence doesn't support it. The district attorney's office comes with a lot of discretion. With a stroke of a pen, you can file charges and change a person's life. With the same stroke of a pen, you can use your discretion not to file charges or to dismiss charges and change the course of a person's life and their family. I was always extremely mindful of that it's extremely powerful, yet profoundly humbling. Out of all of the assignments that I had at the DA's office, I have to say the most professionally fulfilling and personally gratifying and challenging at the same time was when I was on the sexual assault unit, prosecuting rapists, child molesters, human traffickers. And I remember those early days on that unit, being at a social gathering made up of attorneys and non-attorneys, and a lot of them were taking interest in my new assignment, and they were saying, wow, that's so hard. How do you do it? Is it hard to sleep at night, hearing these stories about children? And then another person from the bunch, who happened to be an attorney, said, why do you do it? You know, with your trial experience, go to corporate. You'd make so much more money. And I said, probably, but for me, it's not just about money. And he said, what is it about? And I said, well, I like to think that I'm making a difference. And he said, you think you're making a difference? Kind of mockingly, was a bit of a punch in the gut. But I was reminded of this story about an old man at the beach where the waves had swept up all of these sea urchins to the shore that needed water to survive. And this old man kept bending down, picking an urchin, throwing it back in the water. Bending down, picking an urchin, throwing it back in the water. Then a young guy comes by and says, what are you doing? And he says, well, I'm trying to save them. They need water to survive. And the young guy says, are you kidding? Look, there's like miles of them. Do you think you're making a difference? And the old guy bends down, picks one up, throws it in the water, and says, I made a difference to that one. And so that was my mindset, that there are plenty of sexual assault victims. There are plenty of victims, of course, of all different types of crime. And I may not be able to advocate on behalf of all of them, but with each individual one, I hope to make a difference for that one. This is a sheet of stickers that was given to me by a little 6-year-old victim, or I prefer to call her survivor. She was unfortunately molested at the hands of a family member, and this little girl was extremely courageous, had to be interviewed by police, detectives, come to court, testify during various proceedings, preliminary examination, trial, and at the end of the proceedings, she, when we were saying goodbye, she reached into her little backpack that she had brought to court with her, and she took out the sheet of stickers, and she peeled a couple, and she put it on my blazer, and then she said, actually, I want to give you the whole sheet. And that was her little 6-year-old way of saying thank you. And that was the most precious gift ever. Again, I was not able to make a difference for everyone, but I hope I made a difference to that one. So throughout all of this, as of course I'm prosecuting crimes and teaching at law school, I also felt that need to be more actively involved in the community. Now, a lot of people said, well, you're already doing public service. District Attorney's Office is public service, but I felt an obligation to do more outside of my job and my career, and I felt particularly needed in our Iranian American community. So I ended up joining some of the Iranian American organizations that were sprouting at the time. IABA, as I mentioned, back in 2008, I joined as a member and then ultimately joined the board, ended up being president, and also Public Affairs Alliance of Iranian Americans, Pars Equality Center, and ended up taking leadership positions in all of them. It is so extremely important to be an active participant in our democracy and engage in these very, very important conversations that are going on in our nation. Now, a lot of people would say, how do you do it? And I'm a strong believer of if you want to do something, you find a way. If you don't, you find an excuse. So I found the way: lunch hours, evenings, and weekends. A lot of evenings and weekends. It is a lot of time. It is thankless many of the times, but it's not for thanks from everyone. It ends up being very personally fulfilling and personally gratifying. And I would encourage all of you to find the opportunity. Babak Yousefzadeh talked about it last night, about the different ways that you can help actively engage in your community in whatever way that you can. In addition to that, I also coached a high school mock trial team. It is extremely gratifying to be a role model, a mentor, a sponsor, as Roxana mentioned, to the next generation. Whether it's trial attorneys or in whatever sector, at first it feels as if you're doing them a favor, but after you engage with the youth, you realize that it's actually personally fulfilling yourself, and it's very rewarding. Now, as I was doing all of this, I must have been doing something right, going back to that messy middle that we were talking about, that I was encouraged to take it to the next level. A lot of people started encouraging me to perhaps run for office or go for the judiciary. I knew that I never had any political aspirations, and in fact, I didn't even have any judicial aspirations. But especially when the presiding judge of Santa Clara County had a series of very serious, important conversations with me, really encouraging me to the bench, I decided that I'll give it some real thought. Again, I never had any judicial aspirations when I started law school or even during my career. But Judge Brian Walsh, the presiding judge, he was a legend in civility and professionalism and a legal scholar. And to have him put so much faith and vote of confidence in me, it was truly humbling, but it also, I thought that I shouldn't just write it off as I don't have any judicial aspirations, but reflect on it, give it some serious thought. So, of course, I discussed it with my family. My husband was extremely supportive and just said, you have to go for this. This is your calling. But I also needed to personally feel that this is what I ought to do. So after a lot of reflection, I thought to myself, I've been a public servant my entire career. That's what I've done. And the judiciary is the ultimate public service in the legal profession, and it's a natural extension of my life's work. And once I reached that epiphany, if you will, with myself, I decided to go for it, that it's not for the robe or for the prestige. It's truly because it's public service, and that's what motivated me to finally put in for it. And after I did, it was an extremely long vetting process. If any of you are ever interested, I will share with you the specifics, but just the condensed version. The PDQ, the Personal Data Questionnaire, is 74 questions, full of subparts to subparts. And that was a monster to fill out, from every opposing counsel, most important trials in your career, digging through your background, no skeletons in your closet, everything exposed from your high school up until when you're applying. And then you may or may not hear about the next level. Nothing is guaranteed. It's not like taking the bar result and you find out in 4 months whether you pass or not. You just apply, and then you wait, and then you wait, and then you wait. And you never hear there's no deadline that says by this date you'll know if it advanced or not. You just wait. So then I had learned that it got advanced to the local judiciary committee. That interview was a room full of 25 attorneys sitting around the table, bombarding you with questions. After that, it was the Jenny Commission. This is the Judicial Nomination Evaluation Commission, which you meet with them either in Sacramento or in San Francisco. And that basically, it's two people sitting there from the Jenny Commission. They put a microphone in front of you, and they say, "Do you mind if this is recorded?" And from the very beginning, you feel like, every word that you utter out of your mouth is going to be highly scrutinized. And before going to the Jenny Commission, you have to send a list of 75 personal references. 75, you heard that correctly. This is on top of your opposing counsel and the judges who had appeared in front of. They also send a random sampling of questionnaires to everybody at the DA's office, everybody at the defense bar, if you happen to be in criminal, and then a random sampling of other types of attorneys in your county. So it's truly vetting you, and then you don't know if you're going to make it to the next level, and you wait and you wait and wait, and if you have made it to the next level, then you get the call from Josh Groban, who up until recently was Governor Brown's senior appointment advisor. Actually, just on Wednesday, he was appointed by the governor to the Supreme Court of California. But the meeting with Josh Groban was extremely intense, and I didn't think it went all that well. And then ultimately, I got the call about the appointment. So that was my long and convoluted, messy middle. The being sworn in at the judicial investiture by legendary Judge Walsh, who I have such extreme, I hold him in such extreme regard, and he is truly a mentor and was my champion. And being robed by my immigrant parents, and in a full auditorium with so many of you in the community there, was truly one of the most extraordinary days in my life, and I was delighted to share it with many community members. So as I said at the beginning, the path to the judiciary, there was not a particular blueprint, but I hope that your takeaway is that not to get discouraged when you have pitfalls along the way, not to get discouraged when you come out of a meeting which feels more like a setback than progress. Of course, we're human. Disappointment is part of life and part of human emotion. Take the time to reflect, take the time to take the lessons learned, but stay true to yourself, stay true to your character and your work ethic, and learn from the experiences and keep at it, keep going. Along the way, don't forget to reach out to mentors, and also at the same time, don't forget to turn around and lend a helping hand to a mentee or somebody that you can sponsor. And along the way, you're always going to be looking up to someone for inspiration, but keep in mind that you're already inspiration to someone else that is coming behind you. And there's been a lot of talk about professionalism and civility, especially recently. November 1st, 2018, California Supreme Court just ended up publishing the new version of professionalism and civility. And I would say to you as practicing attorneys that I know that you work in an adversarial process. I get it, I've been there. Be a zealous advocate, be a strong advocate, but maintain your civility throughout all of the interactions. There was the mindfulness training this morning. When you are zealously advocating, also take a deep breath and recognize that your adversary is trying to do their job. And that way, I think it'll bring you calm and it'll give you perspective. And keep in mind that you are also not just a representative of yourself, but you're a representative of our community. So guard that reputation and be the very best version of yourself and our community that you can be. And my final thought is do your best and make a difference to that one. That's all that matters. Thank you very much.
Thank you, Judge Iravani. That was very inspirational, very motivational, and we're very honored to have you as a representative of our community, and I'm sure the Santa Clara court system is very lucky to have you, and with the compassion that you bring to the bench. Thank you. I'm going to turn it over next to Judge Tabaddor to discuss some of the challenges and the hurdles that you have faced on the bench, given the recent challenges and hurdles within the immigration courts. Thank you.
So now it's good afternoon, and I notice it's noon. The two of us are what stands between you and lunch, and we are way past the time. So I'm going to cut my talk in half in respect to your time, and hopefully Judge Sheibani will also have an opportunity to talk before you're too hungry for lunch. But thank you to IABA, and thank you for all of you who are here today on your Saturday. That means a lot. I'm very honored to have been asked to serve on this panel. I was, and you were talking about having been involved with IABA, I'm one of the founding members of the Los Angeles chapter of IABA, and I can't tell you how proud I am to be in this room. It's like seeing your children grow up and go on and do 10 times more than you ever imagined for it. So it's truly just heartwarming. So I always have to speak in my capacity. There's always these disclosures I have to give. I'm here in my capacity as the president of the National Association of Immigration Judges. This may be a bunch of words to you, but I hope to, by the end of this short talk, for it to have something more meaningful to it. My goal is to introduce you to the immigration court system and to hopefully get you a little bit more informed and energized and involved in trying to protect the very principles upon which I hope you went to law school for. And what this means is I see a couple of faces that I know are very deeply familiar with the immigration court system, but raise your hand if you don't know much about the immigration court system. Okay, so that's a good amount. I'm going to give you a little bit of statistics and talk a little bit about the principles, and then maybe end it with a little bit of an ask. And this is unusual because usually the attorneys come to court and are trying to convince the court to do something. I'm here today and I'm moving you and I'm asking you to sit in that judge's seat and say, I hope that I can persuade you and move you to take some action that's much needed in protecting the integrity of the court, independence of the court, and the judges who hear the cases of very important matters before them. So let's take it back a little bit. With some numbers. We have about 390 immigration judges across the country. Immigration law is a federal law, so it applies all across the country. For these 390 judges, they sit in about 60 courts across the country. And there's a backlog of 765,000 cases. So Just do the math, it's really quick. 765,000 cases for, let's up it, 400 judges. Those numbers are staggering. And they're not evenly divided because some of the judges are hearing cases of individuals who are in detention facilities, so they can't put on a lot of cases for that judge because we really want to help move those cases through the system, whereas the others are not in that same situation. They're in sort of a non-detained setting. So I have colleagues who have upwards of 6,000 to 7,000 cases on their docket. So the challenges of being an immigration judge is intense, and the judges are in the courtroom morning and afternoon. Now, when I say immigration judge and I say immigration court, you're lawyers, so I assume that you understand some basic principles of what it means to be a judge and what it means to be in a court, because our American judicial principles have introduced us to those concepts of independence. We have American democratic principles of 3 branches of government: the legislative, the executive, and the judiciary. And the judiciary is supposed to be an equal partner, and it's supposed to be an independent check on the other 2 branches of government. And therefore, when you have a court and when you have judges, and I'm going to introduce you to 2 concepts. The judges have to have decisional independence, which means that the judge's decision has to be protected from interference from external forces. The judge has to be an impartial decision maker, doesn't have a stake in the game, has to be unbiased, and the decision has to be protected from external third-party interference. And the court has to have structural independence, which means the court itself must also be separate and independent from external forces trying to interfere with the governance of the court. Now, immigration court has only one of those 2 criteria. Immigration court has immigration judges who are given decisional independence. So me as a judge coming in, I'm supposed to have decisional independence on the books. So no one is supposed to tell me how to decide a case. And I take that oath of office that I'm going to apply the law, apply the rules based on the case, based on the facts of the case. And I take that very seriously. But as immigration judges, we're placed in an immigration court that is placed in the executive branch. What does that mean? It means my boss is the #1 prosecutor in the country, is the United States Attorney General. We're in the executive branch. So I just want you to pause for a second and say, what does it mean if you went to court before Judge Iravani, and at the end of the day, the prosecutor says, well, Judge, thanks so much for a great job. I disagree. I'm going to take that case and I'm going to overrule you. Now, the judge has said, exercise decisional independence, but structurally, at the end of the day, the prosecutor had the power to come in there and change the rule, take the case, rewrite the case, rewrite the ending, and say, these are now the new rules. So that is what the immigration court system is, and has been. And it's something that I think a lot of people really didn't think much about it, including myself. And I've been in the Justice Department for 20 years. And it wasn't, frankly, until sort of I became a judge and then I started seeing what it means to have a decisional independence in direct clash with structural dependence. We don't have structural independence. And the way that it manifests itself is a constant use of the court for political law enforcement means. So we've seen this for years. Docket shuffling. Again, coming to court and say, thanks, Judge, but today you're going to put these sets of cases in front of these other sets because we want to send a message to this group that we really care about you today. Imagine a court having to be responsive to that. Or coming and saying, okay, we're going to take these cases away from you, we're just going to assign it to you, and then we're going to shuffle it this way. Again, something that would never be tolerated in a traditional, independent court setting. Now, why should you care? You're all probably citizens or certainly have status. You're not going to be the people before the court. But as John Teheranian mentioned before in his talk about sort of diversity, inclusiveness, there is a responsibility to work together. That if you don't protect it for others, who's going to be there to protect it for you? And if you, of all people, the attorneys who I hope went to law school, at least partially because you believe in the principles of our American democratic system, if you don't stand up, if you don't say this is not fair, this is not right, but this is not the way we treat people, then who will? And so I really hope that through this, I know it's a short conversation, I hope that maybe I'm planting a little seed in you and to think about, wait, we studied all of these things, and I don't know how many of you came from Iran, were born in Iran, had to come, okay, fair amount. So you know what it means to have great ideals on paper, but no one protecting it. None of these principles mean anything. Equality doesn't mean anything. Diversity doesn't mean anything until people stand up and say, I demand it to mean something. So you can talk about a court system, you can talk about the American principles. It doesn't mean anything until we actually protect it and stand up for it. So that's, in my capacity as the representative of our National Association of Judges, Immigration Judges, I feel very compelled and honored to have been asked to do this, but I really believe in it. I believe this is something that is so important, not just for the judges to have that true independence, but for the integrity of the whole system and for the integrity of what we stand for the entire world. It's so hypocritical to be talking about democratic principles when it comes to ourselves, to then say, well, actually, we're just going to put our fingers on the scale. Actually, we're just going to give you the veneer of a court. We're going to give you the veneer of a judge. And we're going to give the judge decisional independence. Sure. But in the back, you're moving all the pieces where it's going to have a deep impact on how it's going to end. So what's my ask? I humbly move to have each of you think about what you can do to help remove the immigration court system from the Justice Department and make it an independent court. We call that an Article I court. We've been, it's been a multifaceted progress that we've been making. One is educating the public, because most people don't understand. I didn't understand it. I was in it. And I felt like, oh my God, if people don't understand this concept, how can I ask? How can we ask them? So educating the public. So I ask you to educate your friends, educate your colleagues, educate anyone who's willing to listen, educate them about the challenges facing the immigration court. But then reach out to Congress, reach out to representatives and say, we really need to move the immigration court outside of the Justice Department. And we've been working with a lot of representatives on the Hill, and they're slowly starting to understand what it means. And frankly, because they've now seen the pendulum swing between two administrations who are so different from each other, and saw what happened when it's one way and saw what happened when it's the other way. We're a nonpartisan, non-political organization. I'm here to just deliver the facts. So I ask you to please join me in being committed to really protecting the principles upon which we all took the oath of our office. You took your oath as an officer of the court once you became a lawyer, and really, truly bring the immigration court out of the Justice Department and give it a true independent place in our American judicial system. Thanks for your time.
I chose to speak about diversity and the changes in the criminal justice system because those are two topics that I have a great interest in. Particularly with diversity, there was a recent article that sparked my interest. I'm not sure if anybody read it, in the ABA Journal. And the topic was, does a diverse bench really matter? So I thought about it as a judge, and I sat there and said, does it really matter? Aren't we supposed to be fair, impartial, unbiased? Aren't we supposed to look at the facts in an unbiased perspective and apply the law given to us to the facts? So does a diverse bench really matter? And although I do believe that the law is supposed to be colorblind, But diversity on the bench is important, it's a must, and it should be important to everybody. Because what does a diverse bench do? We every day see thousands, I mean, if you think the judicial system in general, thousands of people come into that courtroom, thousands of litigants. And people who come into that courtroom come from different backgrounds, different experiences, and when they come into the courtroom, they should see a diverse bench. Because what a diverse bench does, it instills public confidence in our system, it instills fairness, and when litigants come out of that courtroom, they should feel that they had a fair chance, a fair opportunity. And so when you only have one particular type of person on the bench, that's not going to instill public confidence in the people that come into the courtroom. So the answer to that question when I read the article is yes, diversity does matter. If you consider just the state of California, we have a very diverse state. I think it's one of the beauties of our state is the diversity that we have. But our bench should also serve that community, that diverse community of the state of California. So when I read that article and I thought about what I was going to talk about today, I said, you know, I'm just going to look up some statistics to see how diverse our bench really is. And so I did. There's about 1,678 sitting judges, and this is all statistics from December of 2017. The 2018 statistics have not come out yet. So that's just an approximation because there's always people that retire, new appointments, but that's approximately how many judges we currently have. If you take just the statistics in the state of California, 40% of our population is Caucasian, but the sitting judges comprise about 67.5% of the bench. African Americans comprise about 6% of the state of California, comprise about 7.3% of the bench. Asian Pacific Islanders comprise about 13% of the state of California, but are only represented about 7.2% of our bench. Latinos, 32% of our state of California population, but are represented only about 10.3% of the state judiciary. Talking about gender, though, 65.5% of our judges are men, 35% are females at this point. And although we look at these statistics and I thought, wow, that's actually terrible, there's been an improvement. If you look back at the statistics from 2006, there has been a slight improvement, but an improvement from what it has been back in 2006. Back in 2006, Asian, they comprised about, 4.4% of the bench. African Americans were only 4.4% of the bench, and Latinos were 6.3% of the bench. So there has been some movement in diversifying the bench, but there can be some improvement. And I think that Governor Brown, I call him Governor Brown 2.0, which is his second term, has really made a concentrated effort to diversify the bench. And if you look at all the firsts, so I went back and looked at what are all the firsts. So I mean by first, all the firsts that were appointed on the bench. We have the first Iranian-American judge, Judge Iravani, appointed to Santa Clara County. She was the first. Some of these are actually shocking to me when I read. The first Filipino-American judge ever appointed to Contra Costa by Governor Brown. The first Filipino-American judge ever appointed to Riverside County during his time period. The first Latino judge ever appointed to Yolo County Superior Court. We now have the first American Muslim judge ever appointed to serve in California. This is actually wrong, they put it on here. The appellate court, the first. I think he was recently appointed last year, or this year.
Los Angeles, I thought.
Yeah, Los Angeles.
I didn't know
No,
it
he
was
actually appointed to the
appellate.
appellate division. And the first Latina judge ever appointed to Riverside County Superior Court. I mean, those are just some of the firsts that I went through. And they were shocking to me to read that these are the first nowadays. I mean, there is some improvement that needs to happen, but I think that Governor Brown and Josh Groban have tried to diversify the bench, and not only in terms of ethnically, racially, or gender, but also in terms of the professional backgrounds that we now see on the bench. I think professional backgrounds of judges are almost just as important as ethnic background, gender, as well as race. Because we as judges, we come from different professional backgrounds and we bring that experience to the bench. And I have seen, I can say particularly with San Diego County, I was a former public defender, and I think about 5 years ago would have been unheard of to have a public defender appointed to the bench. And within the past 5 years in San Diego County, many of my former colleagues have been appointed to the bench. And I think, as Justice Sotomayor, who I love reading her quotes, she said, and I think she said it eloquently to the point, that varied backgrounds help justices educate each other to be better listeners and better thinkers because we understand things from experience. So the experience of these judges who are appointed to the bench is just as important. And I think, as a former public defender, I think it's great to see the diversity on the bench that we have now. And I think it comes in two ways. I think it's important to recognize that our justice system, everyone plays an important role in our justice system. That's prosecutors, defense attorneys, that they all have vital roles in our system. And by appointing people from different backgrounds, I think it's a recognition that the diversity that is brought to the bench is important. But I also think that segues into a different topic. The appointment of public defenders on the bench, I think, was also another sign that our society is changing when it comes to criminal justice reform. We have changed our perspective and the way we think about what's appropriate now for reform. We have changed, I think the bench has changed in how we approach criminal justice as well. And I think that change came about because the voters in the state of California, I have made it very clear that they want some change. And that's based on the multiple propositions that have been passed from 2012 to the present, such as Prop 36 that completely revised the way that we deal with three strikes law now. Prop 47 that decriminalized or actually reduced multiple felony offenses that were low-level drug offenses, petty theft offenses, to misdemeanor offenses. And I think Prop 57 that was passed back in 2016, which played a significant role in the criminal justice system, which dealt with people being able to be released early on parole and the way we treat juveniles in our system. And more recently, which I find interesting, is the reform now with bail. And yet to see exactly what's going to happen with that, but there is some change regarding how we keep people in custody based on the amount of bail or the money to bail out. So there has been significant changes, and I think the bench has reacted to these changes. And I think that the policies that were in place prior, and I led to massive incarceration, longer sentences, and not lower recidivism rates. And I think the bench has recognized that. And nowadays, instead of doing a one-size-fits-all in terms of sentencings, we have expanded our idea of what is an appropriate sentence for every offender that comes into our courtroom. And this new concept of evidence-based practice has been very popular lately. So what evidence-based practice really focuses on is public safety, which obviously is always important, but also the reduction in our recidivism rate. What is best for that individual that comes into our courtroom on an individual basis, not in a sweeping, this is what everybody should get as their sentence. So evidence-based practices now, which is widely used in our criminal justice system, focuses on the needs of that person. Is that person in our courtroom high risk, low risk, medium risk? Would intervention help this person? What is out there for this person to help? Meaning, are there programs? Is there mental health treatment programs, drug treatment programs? What is out there to help this person and in turn help society in general? So I think there has been a complete shift away from incarceration as a solution to everything to looking at the person before you and deciding whether or not the proper sentence for that person. With that came the expansion of programming. And now there's more programs now in our system that I was a public defender for 13 years from when I started being a public defender to when I got appointed to the bench. We have now shifted to this collaborative court mentality that everybody's going to start working together to help these offenders, meaning law enforcement, prosecutors, the judges, defense bar, getting together to find solutions for certain people that will work. And then came the creation of homeless courts, mental health courts, drug courts. I was fortunate enough to recently participate in a drug court graduation as a judge. And it was amazing to me to see the whole community getting together to support these 12 graduates who went through an extensive drug treatment program, supervised for 18 months to 3 years, depending on their offense and their level. And everybody was there. The police officers were there. The probation officers were there. The defense bar was there. The prosecutors were there. Judges were there. And everybody stood up to congratulate these people on their accomplishment. So I think that we are trying now in our system to focus on these collaborative courts to help these people rehabilitate themselves. Sorry, I'm trying to keep it short. And I think the shift in perspective of how we deal with the criminal justice system is just one vital and important point that I was trying to say in terms of diversity and perspectives on the bench, is that when you have people from different backgrounds, different experiences come on the bench, new ideas form, new changes happen, and that's the importance of diversity on the bench. I actually never thought that I would see so many judicial officers on the bench with such diverse professional backgrounds. I never thought it was going to be a possibility until about 5 years ago. And particularly for myself, never thought it was going to be a possibility. And I say this only to encourage people to apply to the bench. And if you never thought it was going to be a possibility, I never thought it was going to be a possibility. I'm an Iranian female, former public defender, appointed to the bench at 39, and there's only 2 Iranians in San Diego County appointed to the bench. So I never thought it was a possibility for me. And I wasn't saying this to say that I think I'm some extraordinary person. As Justice Sotomayor said, and I love this quote that she also says, is that when talking about herself, she said, "I'm an ordinary person who has been blessed with extraordinary opportunities and experiences." And that's how I feel with my job every day. And I hope that some of you one day will apply to be on the bench and be with us so we as a community can create more extraordinary opportunities for other people. So thank you.
Thank you, Judge Sheibani. Thank you to all of our judges. We're very honored and grateful for your time and for being with us today. We hope that this has been inspirational. I think it's really important, not just as Iranians, but just also as women, to be more involved within the judicial system. I think it's very much motivated me to hopefully one day make it to the immigration court bench, hopefully one day. And we really appreciate your commitment and to the bench and in making a difference and really upholding the integrity and bringing your experiences as Iranians. And so I know we're talking about a lot of diversity. I think as Iranians, it's really important that we are represented in the community. So I'd like to thank you very much for being here and for sharing your stories. Thank you.
So it's been a pleasure and an honor, literally seeing so many well-accomplished Iranian women on bench and as a role model. I just want to ask a question about for Judge Sheibani, but anybody else may want to just comment on it. You know, it's great to see all of you Iranian women up there as judges. I'm wondering what you think is preventing as many Iranian men to be on judges. Is that something that John Tehranian said, that they get diluted as a, white men, or other, possible reasons for it? I'm just curious.
You know, that's a hard one. I don't really know. My husband's also Iranian. He's also an attorney, and he told me he would never apply for the bench. And I actually think he'd be a fantastic judge. I think, I'm not sure whether or not they just don't do it. I don't know of many Iranian men who have put their name in to be a judge. So I think they're just not doing it, and so they're not being appointed. I try to encourage people to do it as much as I can, but I just don't know very. Also another topic is that I don't see very many of them in public sector jobs. Let's see, in San Diego County, I think there's only one Iranian male who's a district attorney. There's no my husband was a public defender, but now he's private. That's a very good example. So I think that they're just not applying, and they're not in the job arena. I think DA's, PD's offices tend to be appointed to the bench. So it's unfortunate, I think.
If I may add to that, I agree. I think the same reason why For example, the anecdote that I shared where I was at that gathering and another male attorney asked me, why don't you go to corporate? You'd make so much more money. I think a lot of perhaps male attorneys think that it's more lucrative to be in private sector, and to join the judiciary is not as lucrative. And as I said, it is the ultimate public service in the legal profession. But even though it is a position that comes with so much honor and respect, it's not compensated as well as partners in law firms. So I think people that have elevated to that level of their career, it would be a dramatic drop in income were they to put in for the bench. But I'm encouraged that at least one male last night told me that he's going to put in for the bench, and that will remain a surprise because I think he's incredible and will likely be appointed. So there's hope.
Hi, everyone. So, Judge Sheibani, you actually pointed on the using evidence-based research in kind of guiding you guys' decision-making. So, two questions comes up. Is just one, how would you go as far as controlling for the bias possible, in particular in the field of law compared to someone like a field like medicine? And then how you guys using that as much as that current talk is how these algorithms that for the most part are driven by these analytical studies are driving decision makings might have a little bit of a even like a more racial bias. And what's the direction San Diego County, for example, taking in that regards?
In terms of what?
In regards to like how you guys control for bias, the type of research that you guys use, how you guys utilize the information to come with decision making or processing, like any particular way or direction?
I think that because we're all so independent, all the judges are independent, they base their decisions, again, I think a lot of it is experience. But there isn't any set guidelines, and I do think that there is a trend to use evidence-based practice, but what I mean by evidence-based practice, I wasn't talking specifically about like any statistical evidence-based practice. I meant that the people that come before you in your courtroom, you have to take them as individuals versus everybody fitting in one box in terms of a particular sentence. But I don't use any particular statistics when I make my decisions. I try to look at the person in my courtroom and really figure out what would be the best approach for them, society, public safety. But I'm unsure whether or not.
I think one thing I would add to that is what has happened, which I think is a positive development, is a recognition on the bench that the judicial officers and the judges are human, and that as humans, everybody has implicit biases, and as in people, so yes, we have this ideal, but you're also going through the human sort of filter, and the importance of constantly being mindful of that humanity, of the experience. So the experience is a two-edged sword. So experience certainly informs your decision, but it also limits it, because that's the experience through which you are seeing it. And I think that's why Judge Sheibani's point about diversity on the bench is like, how do you strike that balance? Is you become aware that you're human, you become aware that you have implicit biases, you're constantly having to become mindful. So one of the trainings they do for judges is to constantly tell yourself, I'm human and I have to, would I make this decision if let's say, if the races were reversed, or if the gender was reversed, so that you're constantly engaging in activities to catch yourself, to make sure you're not making decisions that are driven by emotion or by some external stereotypes that are not warranted. And then if you bring in judges from different perspectives and experiences, then you have a much better chance of being able to strike a more fair solution to these issues. So you see the pendulum swinging, because what ends up happening is when there is flexibility shown and a recognition that the judges should be provided much more authority, judges will experiment and judges will sort of do that. And then there's this, then you kind of start to see this wider range of responses to what is perceived to be the same set of circumstances. And then you start to see the pendulum swinging towards guidelines and sentencing guidelines, and let's, take it out of the judges, hands.
I wasn't really clear on my question. How much academic, let's say academic and research-based study
like to look at what programs have proven to be effective in like reducing.
A lot of publications
Yes.
that looks at the past trends, what's the recommendation, what is the data support, and how you guys outline that, because you guys are looking at way more diverse aspects. So like that was the more
Okay.
So, first, I was going to say that there is a lot of unconscious bias training in Judges College. Yes, there's Judges College. When you first get appointed or elected to the bench, within the 2 years, you undergo several weeks of training, and a big component of that is also this unconscious bias and testing and different hypotheticals where it gives you a fact pattern with different socioeconomic, racial, gender, whatever persons being the litigants, and to test if you would decide differently based on the individual demographics of the litigants in front of you. So that's heavily emphasized in Judges College. And then I think what you may be talking about is the risk assessment scores when it comes to arraignment or detention. Gender or race or ethnicity is not a part of it. It has to do with, for example, their failures to appear in court, their criminal history, the use of weapons or not use of weapons, their ties to the community. So it doesn't focus on race and ethnicity at all. It's so many different other factors that goes into the risk assessment score in determining whether somebody is released from custody or bail is set. I'm not sure if that addresses your question, but.
Okay, I think we have one last question, and then we can all go to lunch.
Thank you so much for your great panel. My question is for Judge Tabaddor. Following up with your description of how immigration courts are not exactly as independent as the rest of the judiciary, I was wondering if you could comment on whether things like the travel ban are sort of related on that aspect of half independence or not. Thanks.
I think, I mean, immigration is one of those sort of hotly contested, very debated areas of the law, and traditionally it's, the way it even became such a hotly contested is because the Supreme Court punted on a very, very critical question of, that was born out of the Chinese Exclusion Act. And it was during the time when we were done with all the Chinese labor that we wanted, and now there was this pushback to sort of find ways to exclude Chinese immigrants into the United States. And a test case came out where a Chinese immigrant who had been given residence had left the United States with permission to come back, and that permission was then yanked while he was away, and he sued and said, this is not fair, this is what, you gave me the permission on that basis, on that reliance, like a contractual reliance, I left to come back, and now you're trying to push me out. And when it went to the Supreme Court punted and said, well, this is really not the issue. The issue is really, on question of immigration, how much should we delve into it? How much should we really get in there and serve as a check on the executive? And at that point, they said, our check on the executive is going to be very minimal, because we will categorize this area of law as one that requires a lot more discretion because it's more political, it involves international relations, and so the executive should really be the driving force on that. And then because of that, then it's tailgated into situations that frankly doesn't even have anywhere near the level of sort of flexibility that the executive branch should need in dealing with international matters. So it's connected insofar as, based on our history, the whole thing was swept in as some sort of a highly political area where the Supreme Court kind of just in large part stepped away and said, hey, executive, you take care of it, unless it's absolutely flagrantly indefensible, we're gonna let it go. And therefore then, based on that, the executive has been given a lot of latitude, and so of course with the latitude, I think there's a really famous saying, with power, comes corruption. With absolute power comes absolute corruption. So, and I'm paraphrasing because I know it's not the verbatim, verbatim quote, but I think that's what has happened, is that when that system of checks and balances isn't, balanced well enough, then it's going to allow for these types of encroachment on what would otherwise be considered to be indefensible action.
This question is for Judge Tabaddor. Would you give us some more detail about moving a court under Article 1? What's the timeline like? What procedures do we have to take? And
Sure. So what may come as a surprise to you is that something like this isn't new. What I mean by that is other agencies and other courts have had a similar evolution where, as things developed, it became clearer and clearer that the adjudicative function of that agency really needs to be separated from it because of the influences that the agency was exercising over that process. So the bankruptcy court is an example of how it was born. I forgot which agency, but it was born out of the agency and separated out of it and created as a separate court. And the tax court, is another one that was sort of born out of the agency and then eventually became independent. And in terms of the process, what it requires is frankly a legislative action. So it definitely requires congressional action to create it. It could take many different forms. It could be like bankruptcy court, where it would be with the judicial branch under sort of Article 3 hybrid, or it can be a completely separate entity. So it would just be a standalone immigration court, with its own structure. And there are proposed legislation that have been circulated. The Federal Bar Association has circulated a proposed legislation which would have a dual track. It would be appointment process for the appellate body and then selection process for the court system. So the Federal Bar Association, American Bar Association, National Association of Women's Judges, all of them have come forward in support of the independent court. I'm not sure if that answers it specifically enough, but there's definitely legislation, and timeline is as quickly as Congress will move, and that's as much as pressure they get from people.
Okay, I think that's it for now, everyone.